other candidates, which I am not going to read, aggrieved by the outcome of the election, the applicant contested the results of the election before this court, and this being the court of first instance in challenging the presidential election. The petitioner advanced several grounds of the petition, which I have enumerated below. So, pursuant to the above, he filed this application. Under Section 98 of the Civil Procedure Act, Rule 15 of the Presidential Elections Petition Rules, Order 6, Rules 1920 of CPR, Rules 2, Sub-Rule 2, 42 and 44 of the Supreme Court Rules, seeking orders that leave to amend the petition be granted and cost be provided for. The petitioner had provided several grounds in the affidavit, and the respondents opposed the same by way of filing affidavits in reply, deposed by their respective officers stroke representatives. For the first respondent, they relied on the affidavit of Oscar Kihika, Director of Legal Affairs of the National Resistance Movement. For the second respondent, Biabakama Mugenyi Justice, deposed the affidavit in reply, rebutting the applicant's assertions. And for the third respondent, Jackson Kafuzi, the Deputy Attorney General, deposed affidavit. Representations were as presented by the Attorney General this morning. Both parties, all the parties submitted orally before this court, citing numerous authorities and principles, which I'm not going to read. I now go to the determination of the application. In determining the instant application, we have fully considered the pleadings, the submissions by all counsel, the law, and the authorities cited. But before we go to the merits of the application, we have to consider the objection raised by the applicant regarding affidavit in reply to the application shown by Mr. Oscar Kihika. The applicant raised issue with this affidavit, arguing that the same purports to be the affidavit of the first respondent when it is not. The applicant insisted that the first respondent, the other name is too difficult for me to pronounce, Kaguta, who allegedly had authorized Mr. Kihika to swear the affidavit in reply. The applicant questions the validity of Mr. Kihika's affidavit, given that there is no attachment showing the first respondent that the first respondent authorized him to swear the affidavit on his behalf. The law governing affidavit evidence is Order 19 of the Civil Procedure Rules. The relevant provision is 3.1 of Order 19. The rule provides that affidavits shall be confined to such facts as the deponent is able to, of his or her own knowledge, to prove except on interlocutory applications on which statements of his or her belief may be admitted, provided that the grounds thereof are stated. We have had the benefit of reading the affidavit shown by Mr. Kihika in reply to the application. Paragraph 1 of the said affidavit is worded in the following terms. I am an advocate of the courts of judicature and the Director of Legal Affairs, National Resistance Movement Party, which sponsored the first respondent's candidature in the 2021 presidential elections. I am authorized by the first respondent to swear this affidavit. The reading of the rules cited and reproduced above leads to the conclusion that an affidavit can be sworn by a deponent well versed with the facts within his knowledge relating to the matter before court. Mr. Oscar avers in his affidavit that he is an advocate of the High Court and Director of Legal Affairs of the National Resistance Movement Party that sponsored the first respondent as a presidential candidate. The question as to the sponsorship of the first respondent by the NRM party as a presidential candidate in the elections is not an issue. Those facts are within Kihika's knowledge, which he can rightly depone in that regard. As an advocate and thus the Director of Legal Affairs at NRM, the law permits Mr. Kihika to depone to facts that have come to his knowledge in the course of executing his professional duties, as long as he does not appear to represent a litigant in a matter on whose behalf he swore the affidavit. We refer to R. versus Secretary of State for India. However, where he avers that he had authority to depone the affidavit on behalf of the first respondent, it is trite law that that authority must be explicit in writing. However, to the extent that Mr. Kihika swore the affidavit in his capacity as an advocate for the first respondent, I find the matter in the affidavit is, or in respect of the affidavit, is admissible. Now we move to the merit of the application. The power to receive and adjudicate a presidential petition by Supreme Court is enshrined under Article 104 of the Constitution of the Republic of Uganda, 1995. And for purposes of clarity, the relevant clauses of Article 104, which grant the Supreme Court jurisdiction to hear and determine the petition, are worded in the following terms. I'm going to skip those articles. In line with the clause 9 of Article 104 of the Constitution, Parliament enacted the Presidential Elections Act number 16 of 25. The rules giving effect to the provisions of Section 59 of the Act were put in place as well. Significantly, under the Presidential Elections Act, Section 59 also confers upon the Supreme Court jurisdiction to hear and determine a presidential election petition. Subsections 1, 2, 3, and 5 of Section 59 echo the provisions of Article 104 of the Constitution highlighted above. The Presidential Election Petitions Rules 13 of 201 provide for the procedure of trial of a presidential election petition. The reading of the above legal provisions leads to the conclusion that every event geared towards the determination of a presidential election petition has fixed time frames that require strict compliance. Article 1042 of the Constitution and Section 59(2) of the Presidential Elections Act are couched in mandatory terms, requiring an aggrieved candidate to lodge his or her petition in the Supreme Court registry within 15 days after the declaration of the election results. The court, on the other hand, is commanded by the Constitution to inquire into and determine the petition not later than 45 days from the date the petition is filed. A critical reading of the presidential elections rules indicates that the rules provided for timelines within which the chronology of events geared towards the filing and determination of a presidential election petition are supposed to be performed. The steps leading to the determination of the petition include the presentation of the petition, that is filing at the registry, service of the petition, filing an answer to the petition by the respondents, and trial of the petition. These steps are elucidated under the Section 59, subsections 1, 2, 3, and 5 respectively. Rule 5 of the Presidential Election Rules provides for the mode of presentation of the petition by the petitioner. Rule 6 provides for the mode of serving the petition, and Rule 8 provides for the filing of an answer by the respondents to the petition. Rules 10 and 11 elucidate the mode of trial of the petition, while Rule 12 emphasizes an expeditious hearing of the petition by the court, and the court is commanded to declare its finding in not more than 45 days. The above steps leading to the determination of the petition are worded in mandatory terms which require strict compliance. It thus follows that in determining the petition, the court is restricted to those steps provided for under the law. There is no doubt, therefore, that the intention of the legislature in providing timelines in determination of the petition is to prevent delay and ensure expeditious hearing and conclusion of the election-related disputes. This is to ensure that the country gets back to the normalcy, having gone through a stressful election process. We are fortified by the finding of court in Hammond versus Taylor, Supreme Court of Tennessee, where it was observed that the statute requires all grounds of the contest to be filed within the time provided. Such is the plain meaning and intent of the statute. The legislature has made no provision for extension of time by allowing amendment, and the law makes none. In the absence of such permission under the statute, amendments of this nature cannot be made. Consequently, no new cause of action or contest can be set up by way of amendment. The timelines provided for under the Uganda legal regime are not entirely alien to those of other states within the East African region. And as a matter of comparison, Kenya also applies a similar structure to that of Uganda. In Odinga and 5 others versus Independent Electoral and Boundaries Commission, the Supreme Court of Kenya observed this. The Supreme Court's jurisdiction is also limited in time span. A petition contesting the election of a president does not set off an open-ended cause of litigation without time frames. The applicable time frame within which any challenge to the election must be filed, served, heard, and determined is prescribed under the Constitution. As I stated earlier, Article 104 of the Ugandan Constitution provides for that timeline requirement, and it is a strict adherence. As to whether the law in Uganda relating to the determination of a presidential election petition provides for amendment of pleadings by any party to the proceedings, the available chronology of the steps leading to the determination of the petition does not indicate that amendment of pleadings is envisaged in a presidential election petition. In the instant application, however, the applicant invoking the provisions of Rule 15 of the presidential election rules move this court to have his petition amended. According to the applicant, Rule 15 makes applicable the general law relating to the hearing of civil matters, hence the application of Civil Procedure Act and Civil Procedure Rules. Thus persuaded, the applicant relied on Section 98 and 100 of the Civil Procedure Act and Order 6, Rule 19 and 20 of the Civil Procedure Rules, being the general law governing the amendment of civil proceedings as applicable law in amending the presidential election petition. The applicant further submitted that the framers of the presidential election petition rules were aware that they could not provide exhaustively everything within the rules. The reason they made reference to the existing rules that apply to this court, and that is where a window for making amendment can be found. To ably address this issue, it is imperative that a clear interpretation of the provisions of Rule 15 of the presidential election petition rules be made. And Rule 15 provides as follows: subject to the provisions of these rules, the practice and procedure in respect of a petition shall be regulated as nearly as may be in accordance with the Civil Procedure Act and the rules made under that Act relating to the trial of a suit in the High Court, with such modifications as the court may consider necessary in the interest of justice and expedition of proceedings. The first issue to consider from the above reading is that the rule does not make it mandatory for this court to apply Civil Procedure Act and rules made thereunder in the determination of a presidential election petition, given the use of the phrase may. Secondly, and most relevant, is that if need arose to apply the Civil Procedure Act and the rules, their use would be limited to the trial or hearing of the petition only. It is thus evident that it is only at the trial or hearing of a presidential election petition that the court may apply the Civil Procedure Act and the rules. Anything outside the trial makes the Civil Procedure Act and rules made thereunder inapplicable. Nonetheless, to say the amendment of the petition is not a trial. To this extent, therefore, the authorities of Mulowoza and Brothers versus Enshrine and Co Limited and Mohan Musisi Kiwandoka, cited by the applicant, dealt with amendment of ordinary civil suits and are of no relevance when it comes to the amendment of a presidential election petition. The question as to whether a presidential election petition can ordinarily be amended can only be answered when one examines the value of an election, but most importantly, a petition arising from a presidential election. Undoubtedly, an election is a cornerstone of democracy in which people make choice of leadership. It offers a medium through which citizens freely and fairly choose their representatives and political leadership. It allows a degree of communication between those who govern and the governed. Where the rule of law and democratic principles are upheld, it becomes the most acceptable means of changing political leadership, as the authority of government is derived solely from the consent of the governed. The principal mechanism for translating that consent into government authority is the holding of a free and fair elections. A free and fair election gives the assurance that those who emerge as validly elected leaders govern in accordance with the law. Where, however, there are questions as to whether one has been validly elected, that question has to be valid. That question has to be ably answered through a legal contents, hence a petition. By its own nature, a presidential election petition is unique and therefore accorded special treatment. This is envisaged by the strict timelines within which specific events are supposed to be performed, leading to its final determination, and its trial by and large modifies certain rules of civil proceeding. We have in mind the persuasive decision in Oasis CJN in Urubu versus NEC 1988, 5 NWLR at page 347. Which observed as follows: an election petition is not the same as ordinary civil proceedings. It is a special proceeding because of the nature of elections, which, by reason of their importance to the well-being of a democratic society, are regarded with aura that places them above normal day-to-day transactions between individuals, which give rise to ordinary or general claim in court. As a matter of deliberate policy to enhance urgency, election petitions are expected to be devoid of procedural clogs that cause delay in the disposition of the substantive dispute, unquote. It is in no doubt that the above quotation is in parallel material with the requirements of the Uganda legal regime dealing with the determination of a presidential election petition. The law in this regard evidently treats a presidential election petition not just as an ordinary civil suit, but rather as a unique action that requires special attention. It creates special jurisdiction, and the ordinary rules of procedure in civil cases do not serve to effectuate its purpose. It is thus not surprising that the Constitution of the Republic of Uganda, Presidential Election Act, and the rules do not specifically provide for amendment of pleadings in a presidential election petition. We have already addressed the requirements of the law in regard to strict compliance with the timelines and events leading to the eventual trial and determination of a presidential election petition. The law envisages that once a petition has been filed, the journey towards its final determination commences, which by and large should be uninterrupted. An amendment which could be seen as an interruption towards the expeditious trial of an election petition is not specifically provided for either in the Constitution, the Act, or the rules. If this court were to allow an amendment of a presidential election petition, then it would be acting outside the law that governs the trial and determination of that petition. The respondents submitted that the proposed amendment to the petition by the applicant introduces new causes of action and all grounds, and that if the same were to be allowed, it would prejudice their case. We have had occasion to look at the proposed amendments attached to the application, and they are marked Annexure C. Paragraph 5 of the proposed amendment, in our view, introduces a new cause of action that relates to the qualification of the first respondent as a presidential candidate. In paragraph 5 of the proposed amendment, the applicant avers that contrary to Articles 1021B and 219 of the Constitution of the Republic of Uganda and Section 4B of the Presidential Amendment of the Presidential Elections Act, the first respondent was not qualified for election as president while in the office of head of state, head of government, commander-in-chief, and chairperson of the National Security Council. This ground goes further to point out several acts committed by the first respondent under his command, control, and authority that created insecurity and compromised the freedom, fairness, and voter turnout in the general elections, more especially in the district cities of Kampala, Wakiso, Mukono, Mpigi, Gulu, and Masaka. We have considered the case of Gas Transport Services versus Obene, where the court outlined the principles that govern amendment of pleadings, with emphasis that where an amendment is to occasion injustice to the other side, then such amendments should not be allowed. We have looked at both the original petition and the proposed amendment. It is indeed true that the ground in regard to the qualification of the first was not pleaded in the first petition. Introducing the same in the amendment would amount to introducing a new cause of action, which definitely prejudices the case of the respondents. The applicant relates to this fact in paragraph 12 of the affidavit in support of the application, when he deposed that he had been advised by his lawyers, which advice he believed that particular grounds and prayers were necessary. He added that this could only be introduced by way of an amended petition. Going by this affirmation, it is not in doubt that the applicant is introducing new grounds, which in itself is contrary to the general principles governing amendment of pleadings. In arriving at this finding, we are also persuaded by the decision is Espaneto versus Uganda Commercial Bank, where court observed that a proposed amendment which introduces a new cause of action after the expiry of a period of limitation must be rejected. A similar position was held by the court in Auto Garage and Others versus Motor Cove. Matters are not made any better given the position that the respondents had already filed their respective answers to the petition. And if this court were to allow the amendment, it would necessitate the respondents to amend their respective answers to the petition, which procedural aspects are not provided for under the law for the determination of a presidential petition we have alluded to above. Regarding the argument that the applicant, through his proposed amendment, was introducing new grounds pertaining to non-compliance with the laws and commission of electoral offences, we find that these were already pleaded in the earlier petition filed in this court, and reproducing them in the proposed amendment would be superfluous. There is no restraint to the applicant to produce relevant evidence at the trial to prove the election offences he alleges. As to whether the amendment was filed out of the timelines for filing a presidential petition, it was a respondent's argument that the proposed amendment introduces new grounds and causes of action which are brought outside the permitted time by the law. According to the respondents, the timeline set for doing specific acts in the trial of a presidential petition are well stipulated under the law, and that the applicant cannot be seen to commence a new cause of action outside the law. We have already found that the proposed amendment by the applicant reduces new causes of action, which, if this court were to allow, would be outside the set constitutional timelines. In addressing this question, we are also persuaded by a decision of Rao and others, where it was observed that the general rule is well settled that the statutory requirements of election law must be strictly observed, and that an election contest is not an action at law or a suit in equity, but is purely a statutory proceeding unknown to the common law, and that the court possesses no common law power. It is also well settled that it is a sound principle of natural justice that the success of a candidate who has won at an election should not be lightly interfered with, and any petition seeking such interference must strictly conform to the requirements of the law. We indeed we find that Article 104 makes it mandatory for an aggrieved candidate to file a petition within 15 days after the declaration of results. The applicant complied with that constitutional requirement when he lodged his petition in the registry of this court on the 1st of February. Like we have indicated before, the applicant's attempt to amend his pleadings, wherein he introduces new causes of action, would tantamount to filing his petition outside the time allowed by the law. It was submitted on behalf of the applicant that this is not an application for extension of time. We agree, but must add that this court has no authority to extend the time within which a party would file a petition challenge the results of the petition. This court is in agreement with Madan Agrawal versus Rajiv Gandhi, where it observed that there is a long line of authority for proposition that there can be no amendment to a petition after expiration of time limit. He outlines a number of decisions where the court indicated that an amendment would not be allowed where there was a rigid time limit of time for the presentation of the petition. To allow otherwise would have a practical effect of extending the time for filing the petition. We are very persuaded by the above decision in as far as the limitation imposed on this court by the Constitution to be filed within the time frame. And we rule that the court has no powers to extend that timeline. It was further submitted that by the applicant that he was incarcerated by security forces who restricted his movement when his home was surrounded. We noted that although the applicant was incarcerated, he did have time and space to consult his lawyers, and he confirmed before court that he did have time. So that is not a reason to grant him extension to amend his petition. The applicant referred court to the decision of Mama Babazi versus Yoweri Kaguta Museveni, where the court allowed an amendment to the petition to be made. We have had the benefit of reading the decision of court in a Mama Babazi case. The application was brought under Section 100 of the Civil Procedure Act and Article 126 of the Constitution. We have already indicated before that the Civil Procedure Act and rules do not apply when it comes to the amendment of presidential election petition. We find that this court is restricted by constitutional timelines to conclude the petition within a specific time, which if relaxed, the court will not be in a position to deliver its decision within the time required by the law. While we recognize that the doctrine of precedent is very vital for certainty of laws, we are also aware that the role of the Supreme Court as an apex court in this country is to state the correct position of the law to guide the lower courts. And we are fortified by Article 132(4) of the Constitution. That article provides as follows: the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on question of law. Arising from the above provision, this court has on many occasions departed from its previous decisions for the good of law. A case in point is Rwabugande versus Uganda, Supreme Court Civil Criminal Appeal number 25 of 2014, which is a notorious judgment within this jurisdiction. In view of our analysis above, we conclude that the correct position of the law is that a presidential election petition is not subject to amendment like ordinary suits. We accordingly decline to allow the application. Overall, we find that this application is misconceived and has no merit. Consequently, the same is disallowed as it seeks to introduce new grounds, causes of action not canvassed in the original petition, which is against the general principles governing amendment of pleadings. The proposed amendment also reproduces electoral offenses which we found were already pleaded in the petition, and we categorically stated that the petitioner did not require any amendment, but only evidence in support of those allegations he had made in a pleading. For the above reasons, this application must fail, and we have dismissed it with no orders as to cost.
Thank you, my lord. Call out the next.
Mr. Application number Application number 4 of 2021, arising out of Presidential Election Petition number 1 of 2021, Chagulanyi Sentamu Robert, applicant stroke petitioner, versus Yoweri Museveni to Habura Kaguta, the Electoral Commission, the Attorney General, for the respondents. Quorum is as before.
The ruling of court will be delivered by Lord Justice Paul Mugamba.
This is an application for extension of time to file additional affidavits in presidential election petition number 1 of 2021. I shall go through the basic aspects of the ruling. Three orders were sought. One, that the time granted to the applicant for filing additional evidence in support of the petition be enlarged by 1 extra day to enable him file and serve all his compiled affidavits. Two, that the respondents be given some extra days to file responses. The third was for costs of the application to be provided for. 7 grounds were given for the application. The first was that the applicant filed the presidential petition on the 1st February 2021 and served the respondents. The second was that filing of pleadings was still ongoing. The third was that the filing of additional affidavits in the petition was necessary to enable the court to effectively inquire into and determine all the questions involved in the petition. The fourth was that there were prevailing special circumstances that warranted the grant of the application. Fifth was that the applicant brought the application without any delay. Sixth, that the respondents shall not be prejudiced by the extra time being granted to the petitioner to file and serve additional evidence in the petition. The seventh was that it is in the interest of justice, equity, and fairness that the applicant be granted extra time to file and serve the additional evidence in the petition. There was a background to the application. General elections were held in Uganda on the 14th of January 2021. The applicant and the first respondent were among the 11 candidates who participated in the said election. On the 16th of January 2021, the second respondent declared the first respondent as the validly elected President of the Republic of Uganda. The applicant was aggrieved by the result and filed presidential election petition number 1 of 2021 on the 1st of February 2021, challenging the validity of the election of the first respondent. In the petition, he alleged that the election was not conducted in accordance with the provisions of the relevant electoral laws and that the non-compliance affected the result in a substantial manner. The appellant alleged also that the election was marred with electoral offenses such as violence and intimidation that were committed by the first respondent personally or by his agents with his knowledge, consent, or approval. He prayed inter alia that the election of the first respondent be annulled and set aside and fresh elections be conducted in accordance with the law. Upon service of the petition on them, the respondents filed their respective answers opposing the petition. Thereafter, on the 11th of February 2021, court commenced the hearing of the petition with a scheduling conference during which court issued guidelines or roadmap on the way forward. The court in particular issued the following specific directives regarding the filing of affidavits by the parties, and the parties agreed to adhere by them. Those were: 1. The applicant was directed to file all affidavits by Sunday, the 14th of February 2021. Second, the respondents were directed to file the affidavits in reply by Saturday, 20th February 2021. Third, thereafter, the applicant was directed to file any affidavits in rejoinder by Tuesday, the 23rd of February 2021. An arrangement was put in place for instantaneous service to the opposite parties. The applicant filed a total of 53 affidavits on the 14th February 2021. Apparently, the applicant attempted to file more affidavits on the 15th of February 2021, but the registrar rejected them because he was out of time. This prompted the applicant to lodge the instant application on Wednesday, the 17th February 2021 for extension of time to file the said affidavits. As indicated earlier, court dismissed that application, dismissed it, and reserved the detailed reasons. I shall not delve into the submissions. The basis of the notice of motion giving birth to this application was that Section 98 and 100 of the Civil was Section 98 and 100 of the Civil Procedure Act, Rules 15 and 17 of the Presidential Election Petitions Rules 2001, and Rule 2, Sub-Rule 2 of the Supreme Court Rules. Section 98 of the Civil Procedure Act saves the inherent powers of court to make orders, while Section 100 of the Civil Procedure Act deals with the general power of courts to amend defects or errors in proceedings. They were irrelevant to this application. The same applies to Rule 2, Sub-Rule 2 of the Supreme Court Rules, which governs appeals from the Court of Appeal and the Constitutional Court as per Sub-Rule 1 of the said rule. Rule 15 of the Presidential Election Petitions Rules is equally irrelevant on account of the existence of a specific rule on extension of time, that is Rule 17 of the Presidential Election Petitions Rules, which reads, enlargement or abridgment of time. The court may, of its own motion or on oral application by any party to the proceedings, upon such terms as the justice of the case may require, enlarge or abridge the time appointed by the rules for doing any act if, and here is the emphasis, in the opinion of the court, there exist such special circumstances as make it expedient to do so, except that when considering enlarging time, the court shall take into account the provisions of subsection 3 of section 59 of the Act. We have not laid our hands on any jurisprudence from this court interpreting the above rule. It is clear, however, from the plain language of Rule 17 that it confers a discretion on the court to extend time for doing any act under the rules. The rules do not provide a blank check for extension of time. Like any other judicial discretion, however, it must be exercised judiciously, taking into account the circumstances of the case and in accordance with reason and justice. Therefore, it behoves the party asking for extension of time to demonstrate to the satisfaction of the court that special circumstances exist to make it expedient for court to do so. Arising from the above, the issue of determination by this court was whether the applicant had established that special circumstances existed to warrant the extension of time for filing additional evidence, given the 45 days prescribed under Section 59, Subsection 3 of the Presidential Elections Act for determining the petition. We considered the application, the evidence adduced, the submissions of counsel, the authorities relied on, as well as the law. We found the answer to the above issue in the negative for the following reasons. First, Article 104 of the Constitution and Section 59, Subsection 3 of the Presidential Elections Act give the time frame for presidential election petition as 45 days from the date of filing. The court has no power to extend the same. Pursuant to that, the court held a scheduling conference on the 11th of February 2021 and gave parties very clear timelines within which to file affidavits in the petition. Court went further to instruct the registry to reject any documents that would be filed out of time. The applicant's counsel never complained about the timelines. If anything, he undertook to file 50 affidavits that very day. Secondly, according to Black's Law Dictionary, 9th edition, at page 1270, pleading is defined as a formal document in which a party to a legal proceeding, especially a civil lawsuit, sets forth or responds to allegations, claims, denials, or defenses. In a federal civil procedure, the main pleadings are the plaintiff's complaint and the defendant's answer. In the instant case, the pleadings included the petition and the answers thereto. Rule 5 of the Presidential Election Petitions Rules, 2001, provides that the petition shall be filed at the office of the registrar within 15 days after the declaration of results. Rule 8 of the Presidential Election Petitions Rules, 2001, provides that the respondent who wishes to oppose the petition shall, within 3 days after service of the petition on him or her, file an answer to the petition. Unless the respondent requires further and better particulars, this would technically mark the end of the pleadings. Thereafter, the court shall fix the petition for trial within 5 days. Rule 14 of the Presidential Election Petitions Rules, 2001, provides that evidence at the trial shall be by way of affidavit. Black's Law Dictionary at page 635 defines evidence as something including testimony, documents, intangible objects that tend to prove or disprove the existence of an alleged fact. An affidavit is therefore not technically a pleading, it is evidence. The petition was filed on the 1st of February 2021, and then filing of pleadings was closed on the 6th of February with the filing of the answer by the first respondent. What remained was the filing of affidavit evidence in support of the petition. The issue at hand, therefore, arose out of filing of affidavits, not pleadings. The pleadings were filed within the prescribed time, and there were no issues with them. The allegation in ground 2 of the application that pleadings were still going on is therefore incorrect. Thirdly, court found that the reasons advanced by the applicant as a basis for the inability to file his evidence from the 1st to the 14th of February were not plausible. He deponed in his supporting affidavit that his home was surrounded by security personnel from the 15th to the 25th January 2021, when they withdrew therefrom pursuant to a court order dated 24th January 2021. He deponed also that in the short period of 5 days remaining to file the petition, his lawyers started conducting research and gathering evidence for the intended petition, which they managed to file on the 1st of February 2021. It was his evidence that in the meantime, he and others continued with further preparation and analysis of evidence from all corners of the country, and that he and his party structures obtained more evidence to help in the particularization and support of the grounds pleaded in the petition. He averred that his lawyers advised him that the newly established evidence could only be introduced by way of an amended petition, and that on Thursday, the 4th of February 2021, he paid the prescribed court fees for purposes of filing the amended petition, but that the registrar declined to receive the same and advised him to file a formal application. It is the evidence of the applicant that he proceeded to file an application for amendment, which the court heard and summarily disallowed on the 9th of February 2021 on the ground that the further and better particulars and information sought to be introduced therein could be sufficiently catered for by way of additional evidence. The applicant averred also that during the pre-hearing conference session on 11th February 2021, the court set timelines for filing additional affidavits, and he was supposed to file his additional affidavit by the 14th of February 2021. He deponed that his belief was that, being an inquiry into the election process, which had been conducted over a long period of time, the court would permit him to produce evidence for a substantial duration of the trial, as was the case in previous petitions. He deponed further that, contrary to his belief, the court granted him only 3 days, and he worked with his lawyers round the clock, day and night, so as to file additional affidavits, including taking testimonies from across the country, with some witnesses' evidence being procured from prisons across the country where some of his members are political prisoners. The applicant concluded that despite all odds, they managed to gather over 200 affidavits across the country. The evidence above lacks credibility. Whilst it is demonstrated that the applicant's movement was curtailed by security officers who surrounded his home in Magere after the elections of the 14th January 2021, it is untrue that the applicant was prevented from gathering evidence because he was able to instruct his lawyers, who successfully pursued an application in the High Court on his behalf and obtained an order removing the restrictions imposed on his movement by security officers. Similarly, he could have, if he wished, instructed his said lawyers to collect affidavits in support of his petition, since he did not have to do so personally. In addition, the applicant's affidavit evidence was not convincing. For instance, though he averred that the delay was partly because some of his witnesses were in prison and attached an index of his intended witnesses to the affidavit, he did not highlight or name those who were actually in prison. Court could therefore not discern who was in prison and who was not. Further, there is no cogent reason advanced by the applicant for failure to file in court those affidavits which he purportedly started collecting, according to his affidavit, soon after filing his petition on the 1st of February 2021. It is on record that court started a scheduling conference on the 11th of February 2021. On that day, counsel for the applicant, in his address to court, stated as follows: "We did indicate to counsel that we would be filing about 50 affidavits within the course of today, and all conditions allowing, we would be filing another 50 if you permit." Counsel for the applicant thereafter sought an adjournment to another convenient date when he undertook he would be more organized and prepared. It is on record also that court granted the applicant an additional period up to Sunday, the 14th of February 2021, to file the additional evidence by 5 p.m. that day. Similarly, the respondents were directed to file theirs by Saturday, the 20th February 2021. The applicant was then directed to file his rejoinder by 23rd February 2021. Further, and in a bid to ease and ensure effective service, court directed the parties to designate representatives and avoid them desks at the court premises for that purpose. Court thereafter adjourned the petition to the 24th of February 2021 for conclusion of the scheduling conference and further hearing. We noted that the applicant's counsel never complained that they had any difficulty in meeting the above timeline. We also noted that court had given the applicant 3 more days to gather evidence after he had already had 10 days from the date of filing the petition. On the other hand, the respondents had only 3 days to answer the petition and were added only 6 days to reply to the applicant's evidence. The record indicates that counsel for the applicant never filed a single affidavit pursuant to his undertaking of the 11th February 2021 or at all until the last minute on Sunday, 14th February at 5 p.m. According to the evidence of the respondents' witnesses in reply, corroborated by that of the registrar, on 14th February 2021 at exactly 4:30 p.m., 2 of the applicant's lawyers arrived at the Supreme Court with 7 copies of affidavits bound as Volume 2, which contained 50 affidavits and 3 separate affidavits in spiral binding. After consulting the Chief Justice, the time was extended to 6 p.m. to enable the applicant's counsel to deliver the remaining 13 copies of Volume 2. failure to do so in time, they were informed they would be allowed to file them the next day on Monday, 15th February 2021 at 8 a.m. The registrar waited until 7 p.m. that day, but the applicant's counsel never brought the remaining copies of the said affidavits. This fact was acknowledged by the applicant's counsel in his letter dated 14th February 2021, where he stated that on the said date, we were at court by 5 p.m. with the said affidavits, only that some volumes, particularly volumes 3, 4, 5, and 6, got to court late after the court premises had been closed. On Monday, the 15th February 2021, instead of filing the remaining 13 copies of Volume 2 as expected, the applicant's counsel also brought Volumes 3, 4, 5, and 6, which they tried to file in the registry without leave of court. The registry received the remaining 13 copies of Volume 2, but rightly rejected the rest of the affidavits. According to the record, counsel for the applicant did not file the instant application until Wednesday, 17th February 2021 at 5 p.m. in the evening. It is therefore not true that the application was filed without delay. The court found that if it was indeed true that the applicant had difficulties in assembling his affidavits as alleged, he should have applied for extension of time at the earliest opportunity after the registrar had rejected them, or at least by Tuesday, 16th February 2021, because all parties were fully aware that the registry remained open over weekends and public holidays throughout that period. The excuse that he could not file the application on Tuesday, 16th February 2021 because it was a public holiday is thus untenable. Further, Rule 13 of the Supreme Court rules does not apply to election petitions, since Rule 2, Sub-Rule 1 of the rules clearly limits the scope of the application of the rules to appeals from the Court of Appeal and the Constitutional Court. Based on the foregoing, court found that the applicant was guilty of dilatory conduct. In our judgment, granting the applicant's application would prejudice the respondents, who would have only 6 days to answer allegations contained in over 200 affidavits from witnesses from all over the country. Justice must be for both parties. In the case of Raila Odinga and 5 others versus Independent Electoral and Boundaries Commission and 3 others, the Supreme Court of Kenya stated, the period for the filing, prosecution, and determination of a presidential election is only 14 days from the time the results are declared. This is a very tight, short, and limited period. The background to the setting of the strict timelines must be known to most Kenyans. There was a purpose to this, and the intention of the people of Kenya and of Parliament must be respected. The parties have a duty to ensure they comply with their respective timelines, and the court must adhere to its own. There must be a fair and level playing field so that no party or the court loses the time that he, she, it is entitled to, and no extra burden should be imposed on any party or the court as a result of omissions or inadvertencies which were foreseeable or could have been avoided. The other issue the court must consider when exercising its discretion to allow a further affidavit is the nature, context, and extent of the new material intended to be produced and relied upon. If it is small or limited so that the other party is able to respond to it, then the court ought to be considerate, taking into account all aspects of the matter. However, if the new material is so substantial, involving not only a further affidavit, but massive additional evidence, so as to make it difficult or impossible for the other party to respond effectively, the court must act with abundant caution and care in the exercise of its discretion to grant leave for the filing of further affidavits and or admission of additional evidence. We hold that if we allow the 7 affidavits to remain on record, the same will be prejudicial to the respondents. This will amount to a miscarriage of justice, and we cannot allow it in the circumstances. In that case, the applicants had applied for extension of time to file 7 additional affidavits. The court disallowed the application for a reason similar to what is before us. We found that authority persuasive and applied it to the instant application, since we were dealing with 200 additional affidavits instead of only 7, as was in that case. Lastly, and most fundamentally, we found that granting the extension would negatively impact on the timelines issued by court, in that it would take away 6 out of the 11 days and would leave court with barely 5 days to internalize, evaluate the evidence, and give a reasoned judgment within the 45 days prescribed by the law. As a result of the foregoing reasons, we declined the prayer to exercise the court's discretion in favor of the applicant by a majority of 8 to 1, and accordingly dismissed the application with cause in the cause.
Thank you, my lord. We will have the last ruling, which is a brief one. Can you call the last ruling? It will be delivered by my brother, Lord Justice Ezekiel Mwanguzi. Call it out.
Since application number 5 of 2021, arising out of presidential petition number 1 of 2021, Chagulanyi Center Robert applicant stock petitioner, Pastor Yoweri Museveni to be Habura Kaguta, the Electoral Commission, and the Attorney General for the respondents.
My lord, we'll have to bring the microphone quite close to you.
I think it's on now. Thank you, my lord.
Yeah.
These are the reasons for declining that application. Sorry, for granting the application for withdrawal of the petition. On 5th March 2021, by unanimous decision, the court granted the applicant petitioner leave to withdraw presidential election petition number 1 of 2021. The reasons for the decision were reserved to be given at a later date. The issue of costs was not determined. We now give our reasons for the decision to grant leave to withdraw the petition and resolve the issue of costs. We set out the background of the petition, and specifically we state that 11 candidates contested the election, and we indicate the results as declared by the Electoral Commission for each of the 11 candidates, showing the exact score of votes and the percentages. Yoweri Museveni to Habura Kaguta, the first respondent, having obtained more than 50% of the valid cast votes, was declared winner of the elections. Then we indicate the applicant having filed the application to withdraw the orders, 6 of them, which he sought. We also indicate the answers to that application from the first, second, and third respondents. Then we also indicate that we made a summary ruling in which by unanimous verdict we dismissed the application to amend. Is this the one I'm reading? Or we're indicating that we had dismissed the other one? The ruling is quite long because it also shows the submissions of both parties, the authorities they relied on, and the law. Then we deal with the way we consider the application in court here. We have had the benefit of considering the pleadings and the submissions of counsel for all parties. Needless to say, this was an application for leave to withdraw a presidential election petition. The enabling law is provided for under Section 61 of the Presidential Elections Act and Rule 20 of the Presidential Election Petitions Rules. We reproduce Section 61 of the Act and Rule 20, Sub-Rule 3. Then we say the aforesaid laws can be summarized as follows. 1, the court retains the discretion to permit or grant leave to a petitioner to withdraw the petition. 2, the applicant and his or her advocate must state in their affidavits that no agreement or terms of any kind has been made or undertaking made in relation to the petition. The petitioner and his advocate must respond to the fact that the decision to withdraw the petition has not been influenced by a corrupt motive. 3, if any lawful agreement has in fact been made, the terms of the said agreement should be stated in the affidavit. 4, notice of the application for leave to withdraw the petition has to be made on the court on the court notice board and in the Gazette. The record shows clearly that the applicant complied with the statutory requirements imposed on him in respect of the procedure for filing an application for leave to withdraw the petition. Indeed, he fulfilled a crucial part of the requirements by swearing an affidavit to the effect that the application for leave to withdraw has not been informed by a corrupt motive in paragraph 20 of his affidavit. In support, on paragraph 5 of his advocate Sekaja Ukasha's affidavit, where he states, and we reproduce his statement and that one of Sekaja in paragraph 5. This fact is considered true by all the respondents. We refer to the paragraph 34 of Oscar Chika's affidavit, paragraph 8 of Stephen Tashobia's affidavit, and paragraph 25 of Jackson Kafuzi's affidavit. Notice of the application for leave to withdraw the petition was made by the registrar on the notice board of the court and in the Gazette as required under Rule 20, Sub-Rule 5, Paragraph B of the Presidential Election Petition Rules. Therefore, the application for leave to withdraw the petition, having met all the conditions and procedures required by law, and the respondents having no objection to the application for leave was granted, and the petition was accordingly withdrawn. The court having granted the petitioner leave to withdraw the petition, what remains is for the court to determine the issues of costs and whether court should declare the winner or not. Section 59, subsection 4 of the Presidential Elections Act provides as follows. Where no petition is filed within the time prescribed under the subsection 2, or where a petition having been filed is withdrawn by the person who filed it or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected as president. And subsection 5, on the other hand, provides as follows. After due inquiry under subsection 3, the Supreme Court may A. dismiss the petition, B. declare which candidate was validly elected, or C. annul the election. It is clear that subsection 5 deals with a situation where an election petition is heard to its logical conclusion. Thereafter, one of the options available to the court is expressly provided for in paragraph B to declare which candidate was validly elected. In the instant case, subsection 4 is the applicable provision. It provides inter alia, open quote, the candidate declared elected shall conclusively be taken to have been duly elected as president, close quote. It goes without saying that without a valid and legal challenge to the candidate earlier declared by the Electoral Commission as the winner of the presidential elections stands unchallenged and is taken to be duly elected president. This fact stands whether or not the Supreme Court declares so or remains silent. It's a fait accompli and does not depend on declaration by court. Does that therefore mean that court cannot declare the candidate as the one validly elected? Or can court, following a specific prayer by the respondents or any other party, go ahead and declare the candidate as the one validly elected? For sure, there is no legal impediment against such a pronouncement. However, it would be superfluous to do so. This is because subsection 4 already provides that where a petition is withdrawn, the candidate declared elected shall conclusively be taken to have been duly elected as president. In conclusion, court can safely say that in accordance with section 59 subsection 4 of the Presidential Elections Act, the petition against the declared candidate Yoweri Museveni Tibuhaburwa Kaguta having been withdrawn, he is taken to have been duly elected as president. On costs, section 61 subsection 4 of the Presidential Elections Act provides, open quote, if a petition is withdrawn, the petitioner shall be liable to pay the costs of the respondent, close quote. And Rule 20, Sub-Rule 1 to 7 of the rules reiterates this position. The question to be determined is, are the aforementioned provisions mandatory or directory? To answer this question would require a review of previous decisions of this court in which the interpretation of the word shall has been dealt with. In the case of Site and Sebalu versus Sam K. Njuba and the Electoral Commission, election petition number 26 of 2007, this court discussed section 62 of the Parliamentary Elections Act, where the word shall is used. The court held as follows. It's common ground that although prima facie the use of the word shall in a statutory provision gives the provision a mandatory character, in some circumstances the word is used in a directory sense. Much as we agree with the Land Council for the appellant, to the extent that where a statutory requirement is augmented by a sanction for non-compliance, it is clearly mandatory that cannot be the litmus test, because all too often, particularly in procedural legislation, mandatory provisions are enacted without stipulation of sanctions as to be applied in a case of non-compliance. We also find that the proposal by counsel for the second respondent to restrict the directory interpretation of the word shall to only where it is shown that interpreting it as a mandatory command would lead to absurdity or to inconsistency with the Constitution or statute, would cause injustice, to be an unreliable formula which is not supported by precedent or any other authority. Similarly, in the case of Kampala City Council Authority versus Kabandizi and 10 others, Supreme Court Civil Appeal number 13 of 2014, the court found that the word shall, as used in the provisions of Section 2 of the Civil Procedure Miscellaneous Provisions Act, did not connote a mandatory meaning which required a plaintiff to serve statutory notice on a government, local authority, or scheduled corporation 45 days before instituting a suit against the aforementioned parties. The court, in arriving at the decision that the failure to do so would not vitiate the proceedings, held as follows, open quote, as already stated in this judgment, the rationale for the requirement to serve a statutory notice was to enable a statutory defendant to investigate a case before deciding whether to defend it or even settle it out of court. There was a claim that no statutory notice was served, but the appellant was able to file a written statement of defense and adduce evidence in support of his defense. There was also nothing that stopped the parties from settling the case if ever settlement was an option. This is a clear illustration that failure to serve the statutory notice does not vitiate the proceedings, as the Court of Appeal rightly found. The party who decides to proceed without issuing the statutory notice only risks being denied costs or cause delay of the trial if the statutory defendant was unable to file a defense because she required more time to investigate the matter. Close quote. This, however, does not necessarily mean that this court's position is always directory and not mandatory. In the case of Tamisi Namudu versus Rwabuganda Godfrey, Supreme Court Civil Appeal number 16 of 2014, where the court made determination of the meaning of the word shall in the provisions of Order 5 Rule 13 of the Civil Procedure Rules, the court held as follows, quote, Order 5 Rule 13 clearly states that where summons are issued and service is not effected within 21 days from the date of issue, and no application for extension is made, the suit shall be dismissed without notice. The consequences of failure to serve the summons within 21 days from the date of issue and not making application for extension of time in the prescribed period are clear and straightforward. The provision does not give court discretion to decide whether to dismiss the suit. The action is dictated by law and is mandatory. The dismissal is also effected without notice to the plaintiff. Close quote. From the foregoing, there is no clearly defined threshold for the interpretation of the word shall as used in a statutory provision. However, one thing is clear. The courts look at the intention of Parliament while enacting the various provisions in order to determine what is mandatory or directory. For instance, In the case of KCCA versus Kabandize Supra, it is shown that failure to serve such statutory notice on the appellant did not affect the plaintiff's right to file a defense. The party affected was the plaintiff, who decided to proceed without issuing the statutory notice because he or she risked being denied costs or caused delay of the trial if the statutory defendant was unable to file a defense because she required more time to investigate the matter. The case of Bitamisi Namudu versus Rwabugande Godfrey Supra is distinguishable because the consequences of non-compliance with the provision affected the respondent's right to a fair hearing that is guaranteed under Article 28 of the Constitution. In the instant case, counsel for the applicant invited court to exempt the applicant from paying costs to the respondents and prayed that each party should bear its own costs. His argument was that condemning the applicant in costs would scare away poor litigants seeking legal redress. He relied on the judgment of Sekoko JSC, University Chiza versus Museveni Yoweri Kaguta, and two others, and the case of Raila Amolo Odinga and another versus Independent Electoral and Boundaries Commission and others, Supra, to support the argument that even in cases where a presidential election petition is frivolous, costs should not be awarded against the petitioner. Counsel for the respondents rightly distinguished the cases relied on by the applicant from the instant facts. They correctly argued firstly that in the Kiza Besigye case, the petition was prosecuted till the end, and that in the Raila Odinga case, the petition was also prosecuted to the very end, and that it resulted in the annulment of the election, which was not, they argued, the case in the instant petition, which was prematurely withdrawn. They also argued that this was a proper case for penalizing the petitioner in costs for bad conduct. We agree with the counsel for the respondents that the cases relied upon by the applicants were prosecuted to the very end, unlike in the instant case. Be that as it may, the similarities between the cases are more fundamental than the differences. As much as the instant presidential election petition was not prosecuted to the end, it touches on democracy and the validity of election to the highest office in the land. We are therefore not convinced that the court should apply different principles in light of the withdrawn petition. The same rules regarding costs that applied to previous election petitions in Uganda should therefore apply. In the case of Besigye Kiza versus Museveni Yoweri Kaguta 2001, Odochi CJ stated as follows: in awarding costs, the courts must balance the principle that justice must take its course by compensating the successful litigant against the principle of not discouraging poor litigants from accessing justice through award of exorbitant costs. The risk of having to pay exorbitant costs in a presidential election petition can have a chilling effect on petitions that have merit. It cannot be said that Parliament intended that the risk of having to pay adverse costs should outweigh the benefits accruing from the petition. The decision not to award costs may sometimes encourage and inundate courts with a plethora of frivolous and vexatious petitions, well knowing that there will be no costly financial consequences. The fear of frivolous and vexatious petitions, however, must be weighed against the fear to access justice, which may be caused by award of costs. In our view, the benefit of doubt between being inundated with frivolous and vexatious petitions and access to justice must where pivotal be tilted in favor of access to justice. It is upon this background that to find that the word shall, as contained in the provisions of Section 61, Subsection 4, and Rule 20, Sub-Rule 7 of the Presidential Election Petition and the rules is directory and not mandatory. This means that the general provisions of the law relating to costs should be applied to this case. The law governing the award of costs in civil matters is provided for in Section 27 of the Civil Procedure Act, and we reproduce that provision in extenso. The general position regarding the award of costs is that costs follow the event unless the court orders otherwise for good reason. The power of court to determine costs was explained by Lord Atkinson in Donald Campbell versus Pollack, 1927, Appeal Cases 732. And he stated that law, which we reproduce in extenso. In the case of Kampala City Council Authority versus Kabandizi, this court reiterated the provisions of Section 27, Subsection 1 of the Civil Procedure Act, stating that the court has discretion to award costs, and the successful party is awarded costs unless there are good reasons to deny such party costs. Each case has to be looked at based on its own peculiarities. The circumstances in which it would be appropriate to depart from the rule that costs follow the event were considered by Murray C.J. in the persuasive case of Dunn versus Minister for the Environment, 2007, IESC, at page 60. A decision by the Supreme Court of Ireland, where applying Rule 99 and Rule 1, Sub-Rule 3 and 4, and equivalent to our Section 27, Subsection 1 and 2 of the Civil Procedure Act, which provides that the costs of every issue of fact or law follow the event unless the court otherwise orders. Murray C.J. explained in a long explanation which we reproduce in this ruling. Accordingly, each case has to be looked at based on its peculiarities. Counsel for the respondents argued vehemently that the applicant's notice of motion did not contain a prayer for the exemption from the payment of costs. This was a true assessment of the applicant's pleadings. Ordinarily, this would mean that court cannot consider the issue of costs as parties are bound by their pleadings. However, the court can deal with the matter since the parties were able to address court on the matter of costs. See Sinba K. Limited and others versus Uganda Broadcasting Corporation, Supreme Court Civil Appeal number 14 of 2014. In the instant case, the instant case presents special circumstances that warrant the departure from the general rule that requires costs to follow the event. The special circumstances are that the applicant participated in the 14th January 2021 presidential election and obtained 3,475,298 votes, which is 34.83% of the total votes cast in the country. He brought a petition under Section 59 of the Presidential Election Act, citing incidents of non-compliance with the electoral laws of the country and alleged commission of electoral offenses which were captured in his petition. He terminated the proceedings before the court had the opportunity to inquire into the validity of the allegations. They therefore remain mere allegations. Ordinarily, the petitioner would be ordered to pay costs of the petition to the respondents based on the general rule that costs follow the event. However, the need to promote access to justice in presidential election petitions overrides the need to condemn the applicant to payment of costs. The learned Attorney General urged the court to award the respondents costs due to the applicant's bad behavior. counsel for the applicant argued against this award, submitting that allegations of the applicant's bad behavior were unsubstantiated. Court is inclined to find against the learned Attorney General on the ground that costs are compensatory in nature and not punitive. Before taking leave of this matter, we wish to comment on ground 3 as contained in the applicant's motion, paragraph 19 of the applicant's affidavit in support, and his advocate's affidavit. We will reproduce them for easier reference. Paragraph 3. That procedural rules governing presidential election petitions have been applied to disadvantage the petitioner and his petition in that A, the petitioner's application for amendment of pleadings was disallowed, thus suffocating major grounds from being incorporated into the petition. B, the petitioner's application for extension of time for filing of additional affidavits was disallowed, thus frustrating effective prosecution of the petition. And paragraph 19 of his affidavit stated as follows: that after deeply reflecting upon the foregoing circumstances, I reached the decision that withdrawing the instant petition is the right thing to do, since this court is not handling the petition with the independence, impartiality, and equality I expected of it. The applicant alleged that presidential election petition laws were applied to his disadvantage. He particularly referred to the dismissal of miscellaneous application number 1 of 2001 and miscellaneous application number 4 of 2021. So the application is number 1 of 2021 and number 4 of 2021. He also accused the court of failing to handle the petition with independence, impartiality, and equality. Independence of the judiciary and courts of law is provided for under Article 128 of the Constitution, which we will reproduce in full. The principle of judicial independence aims at protecting judicial decision-making from intimidation and outside interference. Pullman versus Allen, 466 U.S. of 522 of the Supreme Court of the United States, 1984, quoting the Queen versus Beauregard, Supreme Court of Canada, 1987 LRC 180, Justice Tibatemwa JSC in Attorney General versus Gladys Nachibule Chiseka, Supreme Court Constitutional Appeal number 2 of 2016, had the following to say, quote, the purpose of judicial independence is the complete liberty of the judicial officer to impartially and independently decide cases that come before the court, and no outsider, be it government, individual, or other judicial officer, should interfere with the manner in which an officer makes a decision. The applicant's claims are unsubstantiated. He seems to base his claims on the fact that his applications to amend his pleadings and to extend time within which to file additional affidavits outside the scheduled timelines were denied. This denial, rather than being attributed to lack of independence and impartiality, should be attributed to the strict timelines provided by law under Section 59 and the tardiness of his counsel. The timelines are prescribed under Article 104 of the Constitution as amended by the Constitution Amendment Act number 1 of 2018. An aggrieved candidate is required to petition the Supreme Court for an order that a candidate declared elected as president was not validly elected within 15 days of the declaration of the presidential election results. This court is required to inquire into and determine the petition expeditiously and declare its findings and reasons not later than 45 days from the date the petition is filed. Whereas the court can exercise its discretion in ordinary suits to extend the various timelines within which litigants can perform certain acts, the strict constitutional timelines do not allow the court the luxury to do so in presidential election petitions. On the day of pre-hearing, the court, alongside counsel for all parties, agreed to the roadmap which contained the various dates on which the parties were to file their affidavits. Counsel for the applicant assured the court that he would have filed all the affidavits in support of the applicant's case by 14th February 2021. The applicant's counsel, however, failed to do so. This failure can therefore not be visited on the court. All these acts are within the knowledge of counsel for the applicant, who assured the court that, notwithstanding the applicant's affidavit and other utterances attributed to him, the applicant, like the rest of the public, have confidence in the rule of law. Indeed, his having filed the petition and followed procedure to withdraw the same speaks louder about the confidence he has in the rule of law than any utterances made outside court. Sadly, it's not unusual for parties who have been unsuccessful in litigation to label court negatively. Successful parties, on the other hand, are all full of praise. That notwithstanding, all the judicial officers will continue to adhere to their oath to do justice to all manner of people without fear, favor, ill will, or affection. From the submissions of the Attorney General and the affidavits of the respondents, it is clear that the petitioner, on several occasions, through utterances to the media and in diverse places, was trying to interfere with the courts and the judicial officers. Such conduct is not only unconstitutional, it also offends the principle of sub judice. Such conduct is to be condemned in no uncertain terms. The maxim, "He who comes to equity must come with clean hands," prevails. In the result, the following orders are made. 1. The petition stands withdrawn. 2. The candidate declared elected by the Electoral Commission, Yoweri Museveni Tibuhaburwa Kaguta, is duly elected as president. 3. Each party will bear their own costs. Dated at Kampala this day of March 2021. That is the...
Thank you, my Lord and Counsel. We will have a health break of some 30 minutes or so, so we will resume here at 1:30.
Of the day on UBC, brought to you by was brought to you by...
No one should stop you from finishing what's yours. That's why MTN gives you data bundles that don't expire. Load MTN Freedom